So you need to sell yourself. Tell us why you think you are the ideal candidate for this position.
Thank you very much, Your Ladyship. Honorable Commissioners, as I've mentioned, I was admitted to the role of advocate on 13th of October 2005. So this will be my 19th year. Ever since, I've been engaged in active practice from the time of my admission to date. Besides that, I've been a law lecturer from the year 2012. I lectured at Kabarak for 1 year. Then I proceeded on to Moi University, where I've been from 2013 to date. Over the years, Your Ladyship, I've been engaged in active practice and I've handled a lot of matters. The Court of Appeal, the High Court, and all courts of coordinate jurisdiction or equal status to the High Court, and the subordinate courts, and as well as before the tribunals. My lady, in my letter of application, which Your Ladyship doesn't seem to have, but I don't know if that is the same with the other commissioners, I believe they do have it, I've highlighted a number of achievements, and I attached sample cases as requested for in the application. So without going into those cases, if you permit me, Your Ladyship, I will just give you a key highlight of some of the cases which I consider to be very important and very on topical issues which I've handled. Barely a year after my admission, Your Ladyship, my first court appearance was before the Court of Appeal on 28th of September 2006. That was in a civil appeal to number 292 of 2016. I acted for the appellant, which unfortunately we lost in that appeal, but it was a great learning experience to me. A couple of months down the line, in February 2007, I made an appearance before the Court of Appeal again in a criminal appeal in Nakuru, which I successfully prosecuted, and the appellant was ordered set at liberty. Further down, Your Ladyship, in 2008, I filed a matter which I considered to be a very, very key matter insofar as matters children's rights, given me enough skills and experience to handle diverse matters. I also have experience working as a teacher, where I've handled many students, I've examined many students, I've mentored many students, and I've been able to meet deadlines all through, having to set exams, mark exams, and deliver results timelessly. So I believe, Your Ladyship, that over time, and commissioners have acquired enough experience and considerable skills to be able to solve legal questions in a manner that suits the interest of the parties. My lady.
Thank you, Honorable Chair. That's all from me.
Okay, just a few questions. Now, you know, when I look
of stimulating one's thoughts and ideas, because you get some experience or some insights from students which had not occurred to you as a law lecturer. So that way, it challenges you to research further and make you a better person than you were before.
Okay.
Yes.
I'm not by the belittling you know,
no, it's all right.
What you're doing.
Yes.
You know, the reason I'm asking you that, because you can see, having taught since 2012,
yes,
and if, say, we were to say you in the world of academia, then it would then automatically follow, as is always the practice and traditions, that you'd also improve now in that world of academia by, because, you know, I can see you did an LLM.
yes.
The way you know about most of those lecturers, that beyond that, from 2012, they would jump now to do a PhD, you know, which I see is lacking, which means that that's not your forte. Many of them will also write books. I was looking at your, unless it's missing, in your publications, what you've done is to author papers. You're not going to writing to enrich the world of academia.
Yes.
Which is why, you know, I'm questioning whether you're not in a split kind of a situation where, you know, you are becoming a jack of all trades and master of none, you know. So, you know, you still need to convince me that in coming now to the judiciary, it's not yet again being this split situation, indeed there's an interest and you're going to make an impact in the judiciary?
The Honorable Commissioner, I believe that it is not finding myself in a split situation. And just to explain the gap that you've talked about my not undertaking the PhD, if you look at my CV, I've actually indicated that at the moment I'm working on my PhD proposal. And I've actually indicated the topic there. So I'm doing this to give me a better experience or a good grasp of the law in both sides, from both sides, both as a practitioner and as an academician, because just there's what is called learning law by doing law, or experiential learning, if you allow me to use that term.
All right.
Yes.
The PhD bit of it that you're referring to is it's not captured, unless it's, maybe you'd update that. All right, so my final question then.
Yes.
What is the impact that you wish to make as a judge, if indeed you become one? What you'd want to be remembered as, post-retirement, once you've ended your tenure as a judge? That is, if you become one.
Commissioner, I am well grounded in law. I am attentive and detail-oriented. I am patient. I am a creative thinker. And I believe all these together, with what I believe to be my strength, as someone who is very impartial, not biased, and committed to the cause of justice, something which I'm very passionate about, I believe that I'm ready to make a difference and significant contribution in the jurisprudence of this country. Yes.
Yes. Thank you very much, Counsel. I also wish to disclose to the commissioners that you used to appear before me in Nakuru as a young lawyer.
In a number of matters, Your Ladyship.
Yes, and I confirm you are a good lawyer. You are a good court lawyer.
Thank you very much.
Yes. Now, moving on to another area. As you are aware, the Constitution guarantees the independence of the judiciary.
Yes.
And this is not in contention, it's in black and white. Yet we are struggling to assert that independence. Can you give us 3 reasons why that is the case?
Independence of the judiciary, Your Ladyship, I believe is not just a Kenyan problem. It is a problem all over the world where judiciary is struggling to or coming out to assert itself as an independent institution. And there are a number of factors which contribute to this struggle, or which are important in this struggle. One is, though the Constitution actually is clear on separation of powers, in practice, we come to realize that there is a bit of overlap in certain areas, or some interdependence in certain situations. So total independence is not possible. And how to navigate controversies around this area is one issue which I believe is actually contributing a lot to the controversy that is bedeviling, or actually the judiciary is being burdened with when it comes to independence. I'll give an example. Like when it comes to, for example, the question of budgeting or allocation of funds, the judiciary doesn't control the purse strings, for instance. It has to depend on other arms of the government, for example, the legislature, during budgeting, to make provision for judiciary funding. So if there is no collaboration between or among the respective arms of the government, there is no way that actually the institutions can function seamlessly.
Very well. I hope you can write a paper on that as an academic.
Thank you.
To help the members of public understand why this is still a struggle.
Yes.
And that way maybe you can bring out more reasons. Now we are looking for somebody who is judge ready to hit the ground running and deal with a huge backlog of cases and organizations of stations so that they can be efficient. If you are successful in this bid to become a judge of the High Court, just tell us 5 things which you would do to make your court very efficient.
One, Your Ladyship, efficiency is key, and when I read this charge, promoting efficiency is one of the key objectives of the blueprint. So how do you promote efficiency? One of them is with respect to, or with regard to, time management. When I talk about time management, is keeping court time, the time that as a judicial officer you report to court, and if there are any challenges which can make you, or are likely to make you delay or not report in good time, there be communication or proper communication to the various stakeholders concerned. So time management. Number 2, case management. And when I talk about case management, I look at it in different dimensions. One, in terms of how do you prepare cases ready for hearing? And how do you conduct hearings? And what happens once you've conducted hearings in terms of timely delivery of judgments or rulings to the litigants or to the parties, and again making sure that there is proper communication between the court and the various stakeholders or consumers of justice appearing before the court. So case management is very, very important in that, for example, with respect to civil matters, I would employ more of Order 11. I would actually insist on proper implementation of Order 11 of the Civil Procedure Rules, so that way we are able to conduct, for example, pre-trial hearings or conferences in advance. We narrow down on issues which are likely to go for hearing, so that come the time of hearing, we've settled, for example, documents which are to be produced in evidence, we know in advance, so that we don't burden the court by availing very many witnesses whose presence might not even be necessary before court. So that is one way through which I can improve efficiency in my court. Number 3, again, I would embrace alternative dispute resolution mechanisms. For example, ADR. I will review the files and see which ones are appropriate for diversion to be taken through ADR or AJS. That way, you reduce a reduced backlog in court, and I think that will go a long way in improving efficiency, Your Ladyship.
Thank you. Justice Majanja.
Thank you, Chair, and good afternoon once again.
Good afternoon, Judge.
You saw you're in active practice.
Yes, I'm in active practice.
Which is your main court? Where do you practice more?
High Court.
Eldoret?
Nakuru.
In Nakuru.
But even at Milimani, I've got a number of matters. I've appeared before you, Your Ladyship. Sorry, Your Lordship. Yes.
Okay. So, but Nakuru is your main station?
That's where I'm based, but I've got matters all over.
Yes.
Yes.
So, you are a member of a CUC?
Yes.
Which CUC?
I'm not, sorry, I'm a court users committee in Nakuru, yes.
You attend the meetings, or
Yes.
you are a member?
No, I'm not a member, I attend meetings. Yes.
And bar bench?
Yes, I do attend.
Okay.
Yes.
So Nakuru?
Yes.
So what was the latest issue that was under discussion in Nakuru?
One
Last,
issue,
bar bench.
one major issue which was under discussion last time was the question of, or the problems that advocates have with respect to transactions from the lands office.
That
Yes.
was the bar bench.
Yes, all these issues were discussed at the bar bench, yes. Access to the, accessing services at the land office by advocates.
Was that the biggest issue that caused a lot of controversy?
No.
That bar bench?
Another issue was, I think it was in the media, you might have seen it, with respect to access to the court, the gate, one gate which directions had been given based on certain security concerns.
Put yourself as a judge
Yes.
in that court. How would you approach that matter?
How I would approach it is to call all the stakeholders on board and have a discussion so that we get to hear out what concerns the judiciary has and what concerns advocates have, so that we can be able to get a middle ground. And that is what we were able to come up with.
Okay.
Yes.
Thank you. If you come to the High Court and you do appeals, criminal appeals, a bulk of them are from the subordinate court dealing with robbery with violence.
Yes.
And one of the main issues you'll be dealing with is identification. What is a doc identification?
Ad hoc identification
Yes.
is when a witness is asked to identify a suspect or a person of interest before court.
And what is the problem with that?
The problem with that is, especially if this is someone who was not known to the witness before, there is a possibility, one, that this identification could be influenced by some other third parties who could actually be giving the witness certain information or directing the witness to identify the.
Oh, and the person is already in the doc.
Is already in the dock, yes.
So what kind of safeguards have come up to deal with that situation?
The safeguards which have come up to deal with that is, most of the times it is preferable. Evidence of recognition is preferred if someone gives information that I knew this person before and had given, say, prior descriptions of the person.
Mm-hmm.
Yes.
But if not,
If not, if not, then it's not that the evidence will be excluded. It will not be.
what is the normally the safeguard, the procedural issue that you normally deal with?
You would ask the accused, the witness, if, or how did he or she come
What
to
would
know
the investigation what would they have done
They-
before they reach your court? What would they have done before they reach your court?
the investigators.
Yes.
Maybe I'm not getting the question clearly.
I'm saying,
Yes.
you see, you have told us, and we agree, identification parade
The doc identification.
is improper, isn't it?
Yes.
So they have come up with certain safeguards, and none of them is an identification parade, is it?
Yes. Yes.
So you know what an identification parade is?
Correct. Yes. I know.
Give me 3 safeguards of a good identification parade.
A good identification parade. One, you choose persons of almost similar description, be it in terms of appearance, as resemblance,
That's
as
number
close as
one.
possible, height. Then you make sure that when you're going to conduct the identification parade, the witness is not allowed to see them before.
Okay?
Yes.
Then lastly?
Then number 3 is that it should be done at the police station.
Okay.
Yes.
I can live with that. Now, suppose the witness sees the person before the identification parade. Does that render that identification null and void, of is it fatal to a conviction?
No, it is not fatal to a conviction if there are other factors which make that witness credible. It doesn't render the conviction
Okay.
fatal.
Thank you very much.
Thank you.
Thank you, Honorable CJ and Chair. Council,
Yes.
Victory, I've read your sample writings.
Yes, Your Lordship.
It quite shows what a good academician you are. You're a good writer. And it shows in your writings, in your pleadings, in your submissions. They're very well thought out, but very intense. very intense, meaning
Thank you.
you go beyond, pleadings are supposed to be clear, to the point, and just bring out the issues, and the facts don't have to be so, that's part of the evidence,
Thank you.
so detailed.
Yes.
As a counsel,
Yes.
I find that your submissions are really deep, and here you are coming
Yes.
to, you intend to become a judge.
Yes.
Is there any apprehension that in the quest for high quality judgment, and because of your academic background, you will make judgments very, very heavy loaded? Because
Yes.
judgments are supposed to be simple, clear,
Yes.
to the point. The parties get to know how you have reached your judgment, the conclusions and the orders.
I am alive to that fact, Your Lordship, and my answer would be this. It will be determined by the subject matter that I'm dealing with at that point in time. If it is a complex issue, then it requires a lot of input into it, because the High Court is a court which sets jurisprudence. Actually, it's supposed to be relied on it by other courts below. So if it is an area which I still consider to be gray, or somehow which involves some complex issues which require a lot of input, then I would actually, and that's what I meant when I talked about being creative, so creative thinking. Yes, but
Okay.
that would not in any way.
Okay. I also find that
Yes.
you flog an issue with the authorities. You come out with so many authorities on one point.
Yes.
Yet for brevity,
Yes.
you could have just relied on one authority.
Perhaps that is the problem of me being counsel, because I really want my point to sink in. I don't want to leave any loose ends. So maybe when I'm a judge, that would be different. Yes.
When you become a judge,
Yes.
would you feel restrained
Yes.
that you confine yourself to the authorities given to you by the counsel for the parties, or because of the way I see you are good at research and you have that passion? Are there cases sometimes you would wish to bring in cases in your judgment that were not even referred to by the advocates?
My Lord, I would really take that up, and I would not stop at just the authorities which parties have given me, because most of the times there are situations where we have conflicting authorities on the subject, and maybe a party will only submit that which he or she thinks is in support of his or her client's case. So if I end up there, or if I only end there, I may not actually have the benefit of getting the correct picture. So yes, and I'm not saying this out of lack of experience. There are many cases which or authorities which I've even read, judicial officers have actually said that counsel did not even cite to them authorities, but they, out of their own research and industry, they've cited authorities and actually settled the matters that were before them. Yes.
Have you noticed some cases
Yes.
where at the very 11th hour, one counsel introduces authorities, and another counsel objects to that, the lateness of introducing those authorities, and if allowed, they seek more time to respond.
Yes.
Meaning, some counsel are so possessive, they're so determined that they should be given a chance for any cases referred, even by the judge himself.
That is one way to look at it, that they are too possessive, but again I believe that because we are representing clients' interests, and one of the principles of fair trial, that we actually give a party a chance to respond to an issue if it is something which can impact the case. I don't think it would be demanding too much just to say that, no, I've been given this authority here, and I think it raises certain critical issues which are germane to my client's case. I need time to respond. It wouldn't be too much.
Okay.
To ask
Now,
it.
finally,
Yes.
in a summary, give me the essential features of a judgment that that would be necessary in a high court case.
I would start with the introduction, where I briefly outline what the case is about. Then I give background to the case from what I'm able to discern from the pleadings. So if it was a matter which is determined on affidavit evidence, then I look at the respective parties' issues as arising from the evidence, from the affidavit. Or if it is a matter which has been heard orally, then I move on after that background information to analyzing the cases of each parties, of course, starting with the plaintiff's case if it is a civil matter, and then I come to response by the defense. Then, based on that, I frame issues for determination. Then I proceed to analyze these issues. I come up with my determination and then disposition. Yes.
Thank you very much. I wish you all the best.
Thank you, Judge.
Thank you, Chair. Good afternoon once again, Council.
Good afternoon,
I
Commissioner.
agree with Judge Ibrahim that you write very well, and I hope your students will benefit from this type of writing.
Thank you.
I want to make reference to one of the decisions that you have presented to the Commission.
Yes.
That's the ESODO versus Rift Valley Water Services Board. It's an ELC matter in Nakuru.
Number 44 and 45.
Yes, 44 of 2016.
Yes.
It's around violations of certain environmental rights.
Yes.
And among the issues you presented to the court, urging the court to dismiss the petition, was the issue of the petitioners failing to exhaust alternative options, meaning they ought to have gone to other agencies, including, you mentioned the National Environmental Tribunal. Are you aware of any recent development with regards to that particular argument?
Exhaustion of
Alternative options. Your submission was around that the parties ought to have gone to the National Environmental Tribunal.
Yes.
And not the court, the High Court, the ELC court.
Yes.
ELC court.
I am alive to the current decisions, although that part of argument did not carry the day.
No, I just say, I'm not saying it carried, I just want to know
I'll
whether.
give you the Albert Chaurembo case from the Supreme Court, where the court talked about alternative,
Okay.
yes, exhaustion
Okay.
of other
Okay.
remedies, yes.
I just needed to know whether you're aware of that.
I'm
My
aware.
second question
Yes,
is around judicial precedent.
yes.
You know, we are expected, courts of the lower courts and high courts are expected to adhere to judicial precedents. My question around that is what happens if you're appointed a judge and you come across a decision of another judge that you feel should be disturbed?
If it is a judge of coordinate jurisdiction,
Yes.
first, I am not bound by it.
Yes.
It is only persuasive on me. Yes, so I'm not bound by it.
So if you want to disturb that,
And if
will you
I am
just say-
convinced that there have been developments or changes in the law in that particular area, then I will depart from it and
so
give
one
reasons.
is development of the law, the other one?
One is development of the law, or number two, that the decision, maybe at the time that it was decided, there could be some other factors in that particular area which does not make that particular holding tenable at that point in time. Yes.
Any other? I'm okay with that. Thank you.
Thank you very much.
And all the best. Thank you, Chair.
Thank you, Honorable Chair, and welcome again, Honorable Bernard.
Thank you, Commissioner.
Now, when we were preparing for this exercise, we engaged our stakeholders, and they told us that they would want to see a judge who understands the complexity of the judicial system, including the challenging environment and power dynamics. How important is this, and why is it important?
The power dynamics. Allow me to make reference to some book that I was reading, where that is the work of Professor Lawrence Baum, where he talks about judges and their audiences. and it talks about behavioral perspectives of judges. And he mentions three things that which inform a judge's behavior. One, legal. It talks about attitudes or attitudinal, and then strategic. So either of these contexts is important. It is important that a judicial officer is aware of these situations and is alert to know, for example, when I talk about strategic behavioral context, what it implies, what it means is that a judge could be dealing with the law, policy, or both. And it is important as a judge to know that there is the aspect of separation of powers, so that if you're deciding an issue comes before you, you must know, is it something which is truly justiciable as a judicial officer to be able to decide it, or it is something that as a judge you can defer to other arms of the government to be able to deal with this, so that instead of embroiling the judiciary in public controversies, you actually save that time for determining just real legal issues. So a judge must be situationally aware of these challenges and know that there is independence, yes. A judge must act independently, but separation of powers calls upon courts to be able to know when to defer to certain issues which are not within their sphere of competence to deal with.
Thank you. I'm happy with that. Now, how will you leverage on technology as a judge to facilitate social transformation through access to justice?
Technology as a way of facilitating or enhancing social transformation. This is one of the things which I think COVID made it come too early for us, but I think it's a blessing in disguise, because from my office in Nakuru, I'm able to attend to matters in Nakuru at Milimani Commercial Court, Eldoret, and any other station that I could be having a matter. And this helps save time. One, that unlike before, when physical court appearance was mandatory, you had to actually go to court. If I had a matter in Nairobi, I had to actually maybe wake up, leave Nakuru at 4 to be at Milimani Law Courts at 8 or 8:30. Nowadays, that doesn't have to happen. So I'm able to multitask. I can be in my office attending to court, doing pleadings, and attending to clients at the same time. So technology has really gone a long way in improving access to justice countrywide.
Sorry, thank you, my lady. Good afternoon once again.
Good afternoon, Commissioner.
How big is your practice in Nakuru?
We are a medium firm. Yes, a medium-sized law firm.
How many associates?
We used to be 2. My colleague left. Of course, he joined the office of the CJ. Mr. Walter Kobe. So right now I'm the only one with 2 assistants. Yes, 2 students. Yes.
Oh, okay.
Yes.
The other question I want to ask, you've already spoken about case management and what you would do under Order 11.
Yes.
But what of criminal cases? How would you go about pre-trial case management in criminal cases, and what would you be looking to achieve?
Pre-trial management, case management in criminal cases. Allow me to approach it in 2 ways. If it is a case, for instance, involving minors or children, I would, in line with the new developments under the Children Act, try as far as possible to see if diversion is possible, to make sure that we offload them through that system. Adult offenders, at the pretrial stage, I will make sure, of course, this comes after plea taking. I will make sure that there is full discovery there's total disclosure. If it is from the prosecution, they must actually put forth to the accused persons and or the defense counsel. If it be the number, exhibits or the number of witnesses they intend to call, they should make that known beforehand, so that to forestall a situation where on the date of the hearing, a defense counsel comes and says that, no, I've not been supplied with it, witness statements, or I've not seen this. That way, once that is done, and we have known the number of witnesses who are supposed to testify, we've agreed, if possible, Commissioner, I can even allocate timelines, depending on the number of witnesses that I've known that, for example, the prosecution is intending to call. When setting a date for hearing, I will be able to know whether this is a matter which requires, say, a single day, just one day and a couple of hours or minutes, or it might require that we give it 2 or 3 days. Then I know how to plan with the scheduling staff of the judiciary, my calendar. So once that is done, again, but even with respect to adult offenders, if it is possible to promote reconciliation, try AJS, ADR, I will welcome that as a way of, again, easing that burden on the court. And once I'm done with that, then I set a date for hearing.
Are there any preliminary things you would get out of the way at that point before you embark on the hearing?
Preliminary issues?
For those matters that are now scheduled to go for hearing after you've removed the ones that are supposed to go for ADR and diversion?
Yes, if there were any, that's what I said, that if there, at the time of making, pre-trial, I insist on full disclosure to be able to know. If it's about...
Yes, I got that point.
Yes.
Is there any other thing you'll be looking to address at that point?
Oh, the issues of bail, I must have addressed that, of course, bail and bond. Yes, so that if a person is to be admitted to bail, and there's no objection, or if there's objection, I must have made a ruling on whether I'm allowing it or not, and make sure that that again does not come up later on. Or there are instances again where I've come across this. Accused persons come and say that, no, this and these things were taken from me. They are in police custody. I need them. Such kind of things. You would actually make orders to ensure that those ones do not really become stumbling blocks, will be used as excuses to forestall trial. Or to,
okay.
Yes.
Lastly, what is your view about the rollout of judiciary desks at the Huduma centers?
I can report that I attended the online session by Honorable Justice Kimondo. And from where I sit, I think I was able to understand the whole idea behind judiciary desks at Huduma centers. But I think that there's still need to have more collaboration, or sensitization around this area, which I'm glad the Honorable CJ is actually engaging in to diffuse the whole tension around this area, because access to justice is very important. And as much as there is some misunderstanding, I think certain issues which were being raised, or which are being raised by various stakeholders, largely advocates in this particular area, are important, and they need to be addressed. For example, how do we make sure that this is not just another avenue for unqualified people again to take advantage of and abuse to the disadvantage of legal practice. So personally, I'm okay.
By unqualified people, you mean the registry staff?
No, not necessarily. Yeah, could be even registry staff who would perhaps want now to do certain things which they are not supposed to do within that confine of judiciary desk at Huduma centers. So
Huduma centers would facilitate that kind of activity, which is not possible to happen in the registry?
No, it is not that Huduma centers will not be able to facilitate, and that is a concern, that are we not just transferring it from the registry perhaps to Huduma centers? Yes.
Okay, thank you. I wish you well. Thank you, my lady.
Thank you.
Thank you, Chair. Yes, wakili, asante kwa what you've answered so far. Now, I'd like you to tell us what do you feel are the 3 or 4 most important attributes required for this position, and how do you rate yourself in that?
3 attributes of a judicial officer or a judge. 1, a judge must be wise, or you need to exhibit wisdom. Wisdom in terms of how you handle your customers. In this particular case, be they advocates or unrepresented litigants, and also how you write your decisions. So that is 1. Number 2, sobriety. A judge needs to be sober. Number 3, impartiality. You don't need to exhibit any bias towards any party that is appearing before you, whether represented or not. And so that is 3. Wisdom, impartiality, sobriety, and then patience. Yes, a judge, you need to be patient, and where necessary, show empathy. You need to empathize in the serving cases, because you are not dealing with just objects. You are dealing with human beings. Yes.
And how do you rate yourself? Do you?
I fit the bill. I think I fit the bill. Yes.
Yeah.
Yes.
Okay. Now, in your career, can you tell us some achievements you've gotten as a leader? Because, as you are aware, the position you are seeking is also a leadership position for the other courts.
Yes, thank you very much, Commissioner, for that question. At least it gives me the opportunity to discuss or mention the case that I talked about, which I did on extension of parental responsibility. I'm glad that the subject who was involved in this case went on to finish her law career and is now a lawyer serving this country. So I was able to inspire that, just not from representing the case, but in the manner in which I was able to do the case. I really was an inspiration to her. Number 2, in my office, the interns or students that I've had, I've assisted them out in various ways. Most importantly, which I'll mention to the Commission, I've tried to pay to some of them examination fees at the Kenya School of Law, and I think this has really gone a long way to help them. Some of them have gotten admission, and I've done this not just to those who are in my office, but even those who are outside my office I've interacted with. Yes.
Thank you, Honorable CJ. Mr. Akango,
Commissioner, yes.
Yes. We received some of your documents, and of course, because we are expected to do background checks for candidates appearing before us, we noticed that we do not have clearance from HELP.
No, it is there.
You have it?
Yes, I've provided it.
Okay, yes. And you confirm that it's been settled?
Long time ago. In fact, it's HELP who were late in updating their system, but it was done a long time ago.
Okay.
Yes.
Thank you. I'm sure my colleagues can confirm that. Have you ever come to any conflict with the law?
No.
Okay. As you pursue this bid to become a judge, I'm sure you've given much thought to joining the judiciary, and I'm sure you know there are certain things that will change, or there are challenges that you're likely to face. What are some of, give us 3 challenges you think you'll face as a judge, and maybe how you're preparing yourself for it.
One that quickly comes to mind is my social circles. That will definitely change immediately, because as a judicial officer, you need to be seen to be above reproach, and you must not put yourself in a situation which is likely to compromise your duties or to bring your integrity into question. So, and thank God I'm an introverted person. I don't have too many friends, so I think that works well in my favor. Number two, at the family level, I think as a judge and in line with the transformation or the objective that is within the judiciary of establishing high courts at every county, I could be posted anywhere, and that means that I will be staying away from my family. I think this is something that I'm prepared for. We've discussed, and I'm ready for it.
Any other? The third one?
The third one is, of course, my practice. Yes. There's no way that I can transition to the bench and still keep tentacles in my law firm. I would just have to cut links and leave my practice. Yes.
As you were doing our vetting and background checks,
Yes.
one of the reports we received is that you're a very social person.
Yes.
Is that true about you?
I'm
Because-
social, yes. That is very true. But
Yes.
yes. Does not mean that I'm not introverted.
Okay.
Yes.
So does that mean you're going to drop all your friends at once?
No, I will not drop them at once. But how I relate with them, just the way I relate with them currently, we'll have to maintain that professionalism, and at least they'll have to know that maybe there are certain things we used to do together as social friends, which now my position cannot allow me to be doing that on a daily basis with them.
Okay.
Yes.
Final question. Please give us the guiding principles of leadership and integrity.
Article 73 talks of if it is appointment, it should be based on meritocracy. Number two, impartiality. Number three, there should be selfless service based on honesty, accountability, and avoiding conflict of interest. And then number four is accountability and financial prudence if you are managing resources.
Okay.
Yes.
I will take that. Thank you.
Thank you.
Thank you
Honorable-
very much.
Honorable Chair, I actually confirm that Mr. Kango cleared with the Higher Education Loans Board and the certificate is here.
Thank you very much, Council, and thank you very much, Commissioners. I think it's been a very engaging session this afternoon. This brings us to the end of the interview. Before we close, we always give a candidate an opportunity to ask us a question. Yes.
I actually don't have a question, the Honorable Chief Justice and Honorable Commissioners. Mine is to just thank you for affording me this opportunity to appear before you and have this dialogue. I am so grateful for this, and I thank you for the good work you're doing.
On
Yes.
behalf of the Commission, I wish you well and thank you for the good work you're doing, teaching our students, and also providing legal services wherever you do it. Take our greetings to Nakuru
Thank you, Your Ladyship.
and
I
wish
will-
you all the best. We will get in touch when we complete the exercise.
Thank you very much, and you have a good evening too.
Thank you.
Thank you.